We are live this morning.
All right, good morning. We are back in Senate Judiciary on January 21st. We are taking a walkthrough for F-183, and we have Michelle Chow from Pledge Council here with us. So, Michelle, good to see you. And the floor is yours.
Good morning. So for the record, Michelle Child's Office of Legislative Counsel, and we are taking up S-183 as introduced. And I think Emory has provided for you a few documents for your files to take a look at your leisure. There are two trial court opinions, one from Washington unit and one from Franklin, that are kind of the genesis of this proposal. I also provided you with a copy of an act from 2015, which those amendments that were done at that time are kind of at the heart of the matter of what the court was looking at and what you'll be talking about. So home improvement fraud, legislature adopted this new statute in 2003. There have been a few amendments over the years. In 2008, the legislature added the home improvement fraud registry, and then amended it again in 2015. And it removed, and we'll look at the language in it, removed the requirement of intent to defraud at the time that the contract was entered into, which is something that the Supreme Court of the United States has clearly ruled on for a long time, that you have to have as an element of the crime, as a piece and to defraud at the time that they made the contract, and is an element of the crime, and that was removed in the 2015 amendment. And then in 2024, the legislature added land improvement fraud to the statute. So that's kind of a little back story on that. So last year there were two trial court decisions, and they ruled that the post 2015 language, which is the current law, violates the 13th Amendment's prohibition on involuntary servitude. So I know that kind of from hearing folks that kind of straight, and I see Senator Bukowski's look on her face there, and saying, well, what? So 13th Amendment prohibits involuntary servitude, except as a punishment for crime where the party shall have been duly convicted. Voluntary servitude is essentially compelling someone to work against their will. You can do that through coercion, through legal coercion. As I mentioned, the SCOTUS has long held that criminal statute must include as an element of the crime an intent to defraud at the time the contract was entered into, and that laws that seek to criminalize breach of a labor contract without requiring fraudulent intent at the time that the contract was made are a violation of the 13th Amendment. Essentially, the state cannot make failure to labor in discharge of a debt part of an element, one of the elements of a crime. So if we look at the language in your bill, and might be helpful if you have a copy of S-183, as well as Act 13, which is the 2015.
I have 183, but I don't have.
I think everyone have put it in your folders.
I only have 183.
Oh,
wait.
right behind your keys.
There were three. Oh, sorry. This one you're looking at? This one and this one. Sure.
So if you look at the, so it's a number 13, and it says 2015 at the top. You can see what the statute previously had there. So if you just look at page 1 of what was H483, Act number 13, when you're looking at the statute, when you look at subsection B, you'll see that on the in the first sentence, a person commits the offense of home improvement fraud when he or she knowingly enters into a contract or agreement and he or she knowingly, and then it goes through, and previous language, which was promises to performance that he or she does not intend to perform and knows will not be performed in whole or in part. And so what that amendment did is it struck that knowing requirement, right? So we're talking about the mental state that's required as part of the crime. And it essentially made it a strict liability crime, meaning that you don't have to prove any intent at the onset there. Thus, it made a failure to perform the labor and discharge of the debt part of the crime. Because if you look at the language that they added and striking out in subdivision, the existing subdivision 1, it fails to perform the contractor agreement in whole or in part. And when the owner requests performance or refund of payment, the person fails to either refund the payment or make it comply with a definite plan for completion of the work that is agreed to by the owner. So essentially, if you think about it, so you're eliminating the intent, the element of intent to defraud at the beginning of the contract, and then saying down below that if the person does not complete the work and then fails to come up with a plan to complete the work, then they're subject to a fine. And the courts, the trial courts, based again on precedent, have said that that is a coercive inducement for forced labor.
I think it's sort of to use a turn of phrase from Senator Ruth, square that circle. What I am a little confused about, or I guess just have a question about, is if someone pays for work that isn't done, what recourse do they have, or are they just out that money and too bad for them?
Well, I think there's the way to still have a criminal statute. By what I did for this draft, just for introduction purposes to get the conversation going, is I went back to the pre-2015 language, which added back in the knowingly, and went back to the language that is in the statute prior to those changes. So I think you can still have a criminal statute there, and there's also obviously civil remedies. So somebody can sue the person, and generally, breach of contracts are dealt with in the civil context, right? The issue here is the intent to defraud at the beginning, right? Rather than, so if you think of more the situation where a person enters into a contract, has good intent to complete the work, goes out of business, files bankruptcy, or for whatever reason doesn't complete it, it's the civil remedy. The issue is trying to approach it from a criminal standpoint. Thanks. So it's two things at issue there, the intent and about whether or not there's an element around the kind of legal compulsion to complete the work. So let's look at the language in your bill, which as I mentioned, is really just going back to the 2015 language. So subsection A is just your definition section. And so subsection B, we look at the elements of the crime. So that's on page 2, starting on line 17. So a person commits the offense of home improvement or any other fraud. The person knowingly enters into a contract, and it could be for $1,000 or more with an owner for home or land improvement, or it could be for multiple jobs. And then the threshold would be $2,500 for all under the statute. And on page 3, it's just striking the existing language, which is the person knowingly fails to perform the contract or agreement. When the owner requests performance, payment, or a refund of the payment made, the person fails to either refund the payment, make and comply with the completion of the work that was agreed upon. And so instead of that, it again enacts the language from before 2015, which is that the person knowingly promises performance that the person who does not intend to perform or knows will not be performed in full or any part.
So, and this is mens rea that we're talking about. Amazingly hard to prove, unless you had texts or something that,
Right, and I think, I was not a person who had worked on this previously throughout the years and, but just looking at everything and reading the cases, I mean, I can understand from a policy standpoint why those changes were made. There also used to be in an earlier version of permissive inference that was in the statute that was actually struck in the 2015 bill about that if the person doesn't complete the work, you can use that as a permissive inference that they never intended to, and those have been held to be
That's-
unconstitutional.
right?
Right, so that, we didn't bring that one back.
So-
But we added back in the knowing that at the time that you're entering into the contract, the intent is to defraud the person.
So let me ask, make sure I understand the involuntary service. So, if I'm looking at the struck language, failed to perform the contract or agreement in whole or in part. So somebody in good faith says, I'll do this work, takes the money. They go bankrupt, so the money's gone. And then the finding by the Supreme Court was that forcing them to do the work at that point was involuntary servitude.
You got it.
Okay, so that's why it's stripped down to just a knowing wrong.
Right, and so I think the question would be, and I know you'll hear from the Attorney General's office and DSAS on this, they're the ones that work with this statute and have for years, and so they may have some recommendations on another approach. I mean, I think you definitely need the knowing added back in for the, to be clear that at the time the contract was entered, there was an intent, a knowing intent to defraud the person. What you do with these other little pieces, we could kind of, play around with a little bit of the language, but it does make it, as you said, much more difficult to prove, to be able to prove
Yeah.
that when they entered that contract. My guess is, I don't know, but my guess is that probably a lot of these situations involve someone who didn't necessarily intend to skip out with the money, but for whatever reason, failed to do so,
Yeah.
ran out of money and couldn't pay the person back.
So, and this is criminal that we're talking about?
Yes, yep,
And so you would still have the ability in civil court.
correct. Yep.
To sue for these other.
Mhm.
So,
Yeah, you can still go after them in civil court for whatever compensatory damages money
Yeah.
that you paid out to them. If you've accrued, costs because of that failure to perform the work. There's also, because now that this includes land fraud, it could be that someone was going to be maybe harvesting timber on your land, and they did that, didn't complete the work, but then kept the timber and didn't give you, whatever the agreed upon money back that they were supposed to give to you for harvesting the timber. You could get all of those and sue them in civil division.
Senator Lawrence?
So it appears, in my opinion, that the ruling that came down offers more protection for the alleged perpetrator than it does for the victim in the case. But getting back to the knowingly standard, if I tell Senator Ruth I'm going to do this, give me money, then 2 weeks later I go do it, and 3 weeks later I go, and 6 months later nothing is being done. In your opinion, is that knowingly or because there's no time period specified in here, but I've already hit 3 different subjects, shall we say. I've done nothing.
You would have to prove that you were knowingly intending to defraud the person when you entered it.
So after 6 months, 3 different customers, I haven't done anything. That seems kind of common sense to me that, yeah, he or she intended never to do work for any one of them, I guess, but it's a question, it's a gray area.
Well, it'd be a good question for when you hear from the prosecutors on how they approach these cases, right? Because I'm sure that there's many ways that they go about, gathering the evidence to be able to present to the court, that there was an intent to defraud, right? So something like they could say, well, there's 3 different people work was supposed to commence, within 30 days. At 6 months later, no work has been even started on any of the clients' homes. They would, have to make their case.
Yeah, just a comment to that, and then Senator Bohosky, I think, yeah, I mean, there's millions of variables that can go into it, like if somebody took the money and, they're running a legitimate business and their workshop catches on fire and, it's a total loss, that's evidence against, meeting that mens rea, but, somebody who doesn't even have a license or a registration to run a business, they don't have any, there's no experience, there's no background that they have, they're just a person essentially pretending to be a contractor, and they take this money, and then when they take a claim to Canada, those are factors that can be taken in, and, those kind of are the ingredients of baking the cake for proving the mens rea. So, yeah, just
Right, they would look at like what steps have been done in accordance with performance of the work, so were they showing up kind of regularly for a while and doing the work or whatever, and then they lost a couple employees, right? And then work starts to slow down, they can take all those factors into consideration as to whether or not they could prove intent to defraud.
Senator.
Doesn't the Attorney General oversee or regulate contractors?
There is the home improvement fraud registry, and I would say they're going to be witnesses for you to talk to them about the registry. That is something that you can look at, and it's not amended in your bill. But if you look at on S-183 on page 4, subsection C, if someone is convicted of home or land improvement fraud, they go on to this home improvement registry for the AG's office, and essentially they have to post like a surety bond or
Doesn't the, oh, I'm sorry. Go ahead.
No, it's okay. I see where you have that. I guess, as I think about this is consumer protection, which is firmly under the umbrella of the Attorney General. So I guess I'm just wondering if there's actually an Attorney General to take in these instances from a consumer protection framework.
I'm sorry, I didn't quite understand this question.
So as I see contractor fraud, it's like responding to it as consumer protection, which is in my understanding firmly in the home of the Attorney General's office. So I guess what I'm wondering is if there are any actions the Attorney General could take in some of the instances we're talking about to remedy the situation, or if it's just posting.
I don't know.
Okay.
A question for them. This can obviously be prosecuted by either the Attorney General's office or by state's attorneys. I don't know how often those cases where those come down.
Similar question. So I know they take complaints, fraud complaints, and when I was on economic development, we were looking to require written documents, which was a failed trial. We were getting statistics from the fraud division about how many complaints. So they are taking similar complaints. It's just that the registries for people who have been convicted.
Correct.
Yeah. Okay.
Because they essentially have to post a bond that's going to ensure that if they're engaging in that kind of work, that it's covered and people will not be out.
So 2 questions. One is when they have to inform the AG's office, that both on civil and criminal level.
No, this is just under conviction.
Just under conviction.
Under this statute.
But either civil or criminal, or
No, it's just under this criminal statute.
okay. And secondly, if this goes back to a crime versus a civil offense, it would be an expectation of the state's attorney to handle this at that level. I assume.
That the state's attorney instead of the Attorney General's office?
If it's considered a crime versus a civil offense.
Well, it could be either, because they're both have authority to prosecute these crimes. So I maybe ask them how they decide who's gonna take a case and.
I think they rarely do, is what's the point of trust.
I-
Your experience.
Any further testimony or any questions for Michelle? Well, that's a helpful walkthrough, and I think I understand most of it.
I had to read those cases that you've done, so it is.
Oh, yeah, okay. Yeah. I say I understand parts of it, still working through it. I think, we are getting more testimony. Your testimony was very helpful in kind of setting the backdrop to how we got.
Yeah, I'm sure that the prosecutors can fill you in a lot more on their journey
Yes.
with this statute and how often they're prosecuting, whether they're breaking cases.
Well,
And
is this under appeal with any particular county right now?
no,
It is.
no.
Mark had mentioned that. There was a.
No, I mean, I will say, I think the trial court's opinions are pretty solidly based in precedent, around at least the element of that you have to have intent to fraud as an element of the crime.
Yeah, we'll be hearing from a few folks tomorrow, so that'll provide some additional context. Committee, any closing remarks?
Thank you.
Yes, thank you. Great, great.